Hello, everyone, and thank you for attending today's webinar. I'm Betsy Cooper, Director of the AspenTech Policy Hub, and on behalf of the Hub, I want to welcome you to Beyond Chevron, Advancing Nonprofit Advocacy in a New Legal Landscape. For those of you who are new to us, the AspenTech Policy Hub is a West Coast policy incubator, training a new generation of policy entrepreneurs. We take STEM experts, teach them the policy process through fellowship and executive education programs, and encourage them to develop outside the box solutions to society's problems. One of the Hub's goals is to demystify policymaking. We help individuals and nonprofits understand how to effectively advocate for change. And the landscape for that advocacy just changed dramatically. The Supreme Court's recent decision in Loper Bright ended what was called Chevron deference, the deferring of courts to executive agency expertise. As a result, courts now have more power to weigh in on the work of U.S. federal agencies. Today's webinar will help you better understand how to effectively advocate in light of the Loper Bright ruling. You will learn more about how advocates, especially in the nonprofit sector, can adapt their policy and advocacy strategies to be effective in this new regulatory landscape. We're excited to welcome Josh Chaffetz, Professor of Law and Politics at Georgetown University, who will provide an overview of Chevron deference and what it means for agencies in Congress. Then we will turn it over to a panel of experienced nonprofit representatives who will discuss what the decision may mean for outside advocates. We welcome you to submit questions using the Q&A function, as we hope to incorporate your voices in the conversation throughout. I will now hand it over to Andrew Lewis, our Hub Policy Advisor, who will introduce Josh and moderate our panel. Over to you, Andrew.
Thanks, Betsy. Hi, everyone, and thank you for being here today. I'm excited to moderate our conversation and especially to welcome Josh Chaffetz, the Agnes Williams Sesquicentennial Professor of Law and Politics at Georgetown University. So Josh brings a wealth of experience to today's discussion. He spent 12 years on the faculty of Cornell Law School before coming to Georgetown, and he's written extensively about the intersection of law, politics, and public policy. Notably, Josh has literally written the book on legislation and regulation. He's a co-author of one of the leading case books on the subject, which is taught in law schools around the country. So Josh will give us an overview of the Supreme Court's decision overturning Chevron and how it'll affect the work of federal agencies. So over to you, Josh.
Thank you so much, Andrew, and thanks to everyone for being here. It's a real pleasure to be with you today. So what I'm mostly going to focus on in my remarks today is what the Supreme Court's been doing with respect to administrative agencies' policy-making abilities and what that means for the future of regulation. Now, I suspect the panel that follows me will be far more qualified than I am to get into the nitty-gritty of how policy advocates should react to these changes. So I'll simply conclude with some sort of large-scale thoughts along those lines. First, a little bit of background. So the Constitution presupposes the creation of what it calls departments, but it doesn't itself create any kind of administrative structure. It leaves the details of administration to Congress to be worked out via legislation. Now, from the very beginning, Congress has taken the Constitution up on that invitation, passing statutes that created departments, agencies, boards, commissions, etc., and structuring them in various ways to try to accomplish the regulatory goals for which they were created. Now, although these federal administrative structures have been around from the earliest days of the Republic, they really started to grow in the aftermath of the Civil War. And in particular, we might date the beginning of the modern administrative state to the creation of the Interstate Commerce Commission in 1887. The administrative state grew steadily throughout the Gilded Age and especially the Progressive Era, and then truly exploded in size with the New Deal and in response to the Great Depression. And importantly, this growth didn't just involve regulating new areas of national life. It also included a profusion of institutional forms, including, importantly, a number of commissions whose leadership did not serve at the pleasure of the president, and who were therefore at something of a remove from day-to-day partisan politics. Put simply, the modern administrative state is a heterogeneous beast with various commissions, boards, agencies, etc., taking various forms and performing various functions. Now, both the form that these agencies take and the functions that they perform are dictated in the first instance by statutes passed by Congress. Congress will pass statutes that create and structure agencies, and Congress will pass the statutes that these agencies administer. So when it passes such a statute, say, for example, the Clean Air Act, that statute will delegate authority to an agency. So in this example, the act delegates authority to the Environmental Protection Agency to regulate air pollutants. Now, those delegations almost necessarily involve both discretion and ambiguity. So by discretion, I mean that they are intentionally and more or less explicitly, that they intentionally and more or less explicitly leave certain judgments in the hands of the agency. And there are certain sort of linguistic formulations that Congress will use to do this. So a statute that tells an agency to regulate reasonably, or to regulate in the public interest, or in the context of the Clean Air Act, to regulate pollutants that are reasonably anticipated to endanger public health or welfare. Right? Those kinds of statutes constitute a delegation of discretion to the agency. Or put differently, they are explicit directions to bring agency expertise to bear on the problem. Now, by ambiguity, on the other hand, I mean that the meaning of the statutory delegation is unclear or underdetermined. Now, this might be intentional. It might be because it was the only way to get enough votes for the bill, right? Sometimes it's easier to coalesce a majority around something if you don't fully specify what they are in fact coalescing around. But it might equally well be unintentional because, for example, something that seemed clear when the statute was drafted is subsequently rendered unclear by later events or by changes in science or technology. Now, traditionally, the only judicial check on Congress's delegation of discretion, the first of these two categories, has been the so-called non-delegation doctrine, which said that any delegation of authority to agencies had to contain an intelligible principle to guide the agency. Now, this has long been understood to be a very sort of easily satisfied standard. And indeed, the Supreme Court, for its entire history, has only struck down 2 statutes on non-delegation doctrine grounds, and both of those statutes were struck down in 1935, right? So almost 90 years ago. Now, the other issue, as I mentioned, is ambiguity. So between 1984 and 2.5 months ago, ambiguity was governed by the so-called Chevron framework, which said that if a statute is unclear, then the courts should defer to the agency's interpretation so long as that interpretation is reasonable. Right? So it didn't have to think that the agency's interpretation was correct or the best interpretation. It just had to be a reasonable interpretation of the statute. So the facts of the Chevron case itself might help flesh this out a little bit. The Clean Air Act amendments of 1977 had required certain states to establish a permitting program regulating what it called new or modified major stationary sources of air pollution with stringent requirements for issuing a permit. But the question in the Chevron case is what constituted a stationary source of air pollution? Is each individual smokestack a stationary source, or is an entire manufacturing plant a stationary source? Now, the statute itself didn't say. The legislative history didn't provide any useful guidance at all. So the EPA sort of thought about it and adopted a plant-wide definition of stationary source, which meant that they would allow an existing plant to install or modify a piece of equipment without a permit, as long as the total emissions from the plant didn't increase as a result. Under circumstances like that, the justices on the Supreme Court in 1984 quite reasonably thought that it made sense to defer to EPA's interpretation. It was a reasonable reading of the statute, and it was one that leveraged both EPA's scientific expertise and its more holistic understanding of the agency's mission. So until quite recently, when I think the best description would be that the courts had been relatively content to police the outer boundaries of agency structuring and decision-making, but generally to defer to Congress and the agencies themselves about anything more detailed than that. But today's Supreme Court has effectively trashed all that in the service of an agenda that is institutionally hostile to the forms of the administrative state, substantively hostile to most forms of regulation, and institutionally invested in aggrandizing its own power. Put together, these don't bode particularly well for effective policymaking going forward. So just to run somewhat quickly through the set of sort of recent actions by the Supreme Court. So first of all, in a series of cases since 2010, the Supreme Court has undermined Congress's ability to structure agencies in the way that Congress wants. And in particular, it has limited the ways that Congress can insulate agency decision makers from presidential control. In a series of cases from the last couple of years, it's made it easier for regulated entities to sue agencies, and it's limited the types of remedies that agencies can seek using in-house adjudication. And while it hasn't formally, officially reinvigorated the non-delegation doctrine, although I should note that a majority of justices have in separate writings indicated a willingness to do so. So it hasn't done that formally, but it has done so de facto by developing the so-called major questions doctrine, under which Congress must be sort of implausibly, almost microscopically precise before it can delegate to an agency any authority that a majority of the Supreme Court considers to be major. Part of the problem here is that the criteria for majorness are deliberately vague, including what Neil Gorsuch has described as matters of great political significance or of earnest and profound debate across the country. So the way I like to think of that is something could be a major question if Neil Gorsuch saw it on Fox News last night. In the last 4 years, this beefed up major questions doctrine has been used to strike down important environmental and pandemic-related agency regulations, as well as an eviction moratorium and student loan forgiveness. And then finally, in the Loper Bright case from late June of this year, the court abandoned the Chevron regime and held that courts do not owe any deference to agency interpretations of the statutes that they administer, although they can take the agency's views into account if they so choose. Now, as if to highlight what a bad decision Loper Bright was, the day before it was issued, the Supreme Court issued another decision called Ohio versus Environmental Protection Agency, in which Neil Gorsuch repeatedly referred to nitrogen oxide, an air pollutant, as nitrous oxide, also known as laughing gas. Now, neither Gorsuch nor his clerks, nor the other justices who signed on to the opinion, nor anyone else at the Supreme Court caught the error until after the opinion was published. It was corrected later that day after public mockery. So what all of this means is that judges who, as a group, have little to no understanding of most of the social, technological, or scientific underpinnings of policy are empowering themselves both to second guess the experts and to undermine the policymaking structures that Congress has put in place via legislation. So if we combine the Supreme Court majority's substantively deregulatory agenda with its decisions anointing itself the arbiter of regulatory policy, what we're left with is a judiciary that's likely to stymie aggressive attempts at regulation more or less across the board. Rational agencies will respond to this by trimming their sails, issuing less ambitious regulations and refraining from doing legal interpretation at all to the greatest extent possible. Okay, so what does this all mean for policy advocates? And as I said at the beginning, I think you'll hear from the real experts on that question next. So I just want to offer a few high-level thoughts. But I'll say right off the bat, it's depressing. I don't have a magic bullet to offer you, but I do have a few suggestions that might help at the margins. So first, you might need to press Congress to be more specific in bill drafting. That is, to reduce ambiguities wherever possible, and to reduce the scope of delegations in big ticket areas where judges are likely to bring the major questions doctrine into play. In less controversial areas, you might press Congress to be more explicit in its delegations so that agency discretion is not a matter of inference, but one of clear statutory text. Second, and relatedly, you might need to press Congress to invest in itself. Congress has fewer staff than it did in the 1980s, and in real dollars, those staff are worse paid. It has neither the staff nor the infrastructure to make granular policy. And yet the judiciary is telling us that if policy is to be made, more of the work has to be done by the legislature. So if you as advocates want that policy to be made, you may need concomitantly to press Congress to increase its own capacity. And I should say that the work that the House Select Committee on the Modernization of Congress did in the 116th and 117th Congresses, work that's now been passed to a subcommittee of the Committee on House Administration, is a good start and a good model for further reforms, but a lot more needs to be done. Third, in bill drafting, you might suggest that challenges to agency regulations be steered towards the DC Circuit Court of Appeals rather than letting the challenging party choose where to file. The DC Circuit will be, for the foreseeable future, more hospitable to regulation than, say, the Fifth Circuit, which is where a lot of people who are interested in challenging regulations will file if they have the choice. Now, of course, this won't prevent the Supreme Court from reversing, but the Supreme Court is relatively lazy. It hears relatively few cases, and it won't catch everything. Fourth, in talking to agencies themselves, you might want to suggest that they not claim to be putting forward interpretations of the governing statutes and that they downplay the majorness of any particular regulation. This may help avoid judicial scrutiny at the margins. Fifth, and finally, it's worth emphasizing that the preceding four suggestions are basically tinkering around the edges. The judiciary is the problem here, and effective policy advocacy in the future may in fact depend on effective advocacy for delegitimizing and thereby disempowering the courts. So on that happy note, I will open it up for questions. Thank you very much.
Thank you, Josh. So we have a few questions from the audience, and just as a reminder, if you have questions, please use the Q&A function in Zoom. So the first one for you, Josh, is about statutory authority. So much of what the government does is based on statutes that were passed like decades ago or over 100 years ago in terms of like antitrust laws and others. So do you think there's a need for Congress to revisit past laws and make them more explicit in light of Chevron being overturned?
There may well be. I mean, so one of the things that Congress often does when it's drafting these important pieces of legislation is draft them with an eye to the future, right? So the reason that something like the Sherman Antitrust Act or more recently environmental statutes are not incredibly specific is because Congress understands that economic understandings will change, or scientific understandings will change, or the technologies will change, and it wants to leave open the possibility of sort of evolution within the existing statutory framework. By sort of coming in with things like the major questions doctrine and the erosion of Chevron deference, right, the court is making it harder to create these sort of open-ended statutory schemes, which may mean that Congress is going to have to revisit these issues more and more frequently. And then the question is, in a relatively polarized political environment, right, what is Congress's capacity to do that? And even when you have, majorities in both houses of Congress that are interested in doing that, right, does Congress have the capacity? So this goes back to the point I was making earlier about Congress needing to engage in capacity building.
Right. Yeah, thank you. Our next question is about one of your concluding remarks that this is very depressing. So are there any silver linings to this for anyone out there? It seems like it's only bad for agencies and governance to overturn Chevron. Like, who benefits from this?
So I think, who benefits from this? There are a couple answers. One is that the court as an institution benefits from this, right? So this, this is gathering power both from the agencies and from Congress itself. This is a lot of the rhetoric in these cases is about empowering Congress, but in fact, what this is doing is sort of overriding congressional wishes and taking that power to decide into the courts itself. So the courts are a major beneficiary here. And then in many cases, regulated industries are a major beneficiary, right? Because this is a court that is sort of substantively deregulatory. And so industries that don't want to be regulated, industries that are potentially polluting, or a lot of these cases deal with the Consumer Financial Protection Bureau. So large financial institutions, right? They're benefiting from this because the regulations that would otherwise govern them are being struck down.
Great, thank you. Next question is also related to one of your previous remarks in conclusion. So you talked about how Congress needs to react by, in one part, adding additional staff with expertise to write laws. Like, do you think that under these circumstances, the courts too would also need to add more staff to research and advise judges? So how do you imagine the courts reacting to what's expected to be an increased workload with more nuanced and technical questions that they have to deal with?
That's a great question, right? And one would hope that judges are embarrassed by things like confusing nitrogen oxide and nitrous oxide in a way that would suggest to them that expertise is valuable. Now, of course, that expertise is housed in the agencies. They could sort of bring additional capacity on board. That doesn't seem likely to me. I have trouble imagining, the federal courts sort of deciding to start hiring chemists or AI experts or engineers or whatever to help them decide cases. I think more plausibly, they're simply, on issues that they don't think have big political salience, what they will do is defer to the agencies the way they have in the past, right? If it doesn't rise to the cable news level, then hey, the agencies, we'll just side with the agencies. And if it does, then we've left open to ourselves the possibility of striking down the regulation.
Yeah, thank you. And we have time for one more question. So do you think that the government, in light of Chevron being overturned, do you think that the government still has the power to make big policy changes without being second guessed by the courts?
The courts have been in the habit of second guessing major policy changes for since at least the middle of the 20th century in this country. I think that there are things that Congress can do that even this court will not strike down. I think that what administrative agencies can do without running afoul of the courts, again in sort of more controversial, more high-profile areas, is severely limited, especially by the Roberts Court. But I think if Congress legislates with a sufficient degree of specificity, I think even this court will feel at least somewhat embarrassed in striking it down. And so I think there is the possibility for significant reform through legislation, but it faces significant headwinds, and agencies face even more headwinds. And when Congress's choice to delegate things to agencies faces, in some ways, the most significant headwinds of all.
Awesome. Thank you, Josh. Thank you for this wonderfully informative overview, a little depressing overview of our regulatory
Sorry about
landscape.
that.
No worries. That's our current state of affairs. So we have a couple of more questions coming in the chat that we may drop in if you want to stick around. But otherwise, again, feel free to drop off, Josh. And I will turn to the next section of our program, which is our panel of advocates who are experienced with regulatory matters and are happy to share their perspective on this new landscape. So first, we have Sanjay Narayan, who's a managing attorney with the Sierra Club's environmental law program and its chief appellate counsel. So Sanjay has represented the Sierra Club in multiple state and federal courts, including at the U.S. Supreme Court. Next is Corinne McSherry, who is the legal director at the Electronic Frontier Foundation. There, she specializes in intellectual property, open access, and free speech issues. Finally, we have Mallory Morales, who is a lawyer at Davis Wright Tremaine LLP, where she advises nonprofits and philanthropists on state and federal rules involving things like lobbying, fundraising, and other issues. So Mallory spent a good chunk of her career with Boulder Advocacy, which is a project that focuses on protecting the rights of nonprofits to advocate for policy change. So she's very experienced in advising nonprofits on tricky regulatory and legal issues involving advocacy. So thank you so much to each of you for joining us today. And please, join us on camera as well if you haven't already. So to kick things off, I know each of you come from organizations that work in different areas and you have different backgrounds. All of you have experience with how nonprofits influence policy by affecting how regulations are interpreted and enforced. So could you share a little bit about your current work, particularly the agency-related work that you or your partners think might be affected by Chevron being overturned? And maybe we can begin with you, Sanjay.
Sure, and thanks very much for having me. So, I work with the Sierra Club, which mostly focuses on trying to secure clean air, clean water, and combat the worst effects of climate change, as well as protect species and environmental quality. All of those policy areas are ones that function in large part through the partnership that Professor Chaffetz described, right? You have Congress passing broad statutes that set out frameworks to achieve ends like clean air. And then you have agencies implementing those statutes to achieve those goals over time across changing circumstances and industries. And in that description, you can sort of see why, in particular, for things like clean air, clean water, doctrines like Chevron are important because they're really across all these areas. What you have are places where the law intersects with science and engineering, right? If you're going to implement the Endangered Species Act, you need to understand something about wildlife biology. And these things change over time, right? The nature is what you know changes, the nature of species population changes, and then climate change happens, right? That changes too. Clean Air Act, Clean Water Act, you're regulating complex industries, dealing with difficult epidemiological questions that where science changes over time. In all of these places, you see both the explicit delegation of discretion that Professor Chaps described, but also these interstitial areas where you have ambiguities that provide play in the joints that has proven especially critical to effectively administering all of those laws.
Yeah, thank you. How about Corinne?
Yeah, so EFF works on digital rights issues across a number of different areas, and a lot of them do involve agencies. And one of the kind of sad things is that currently we have agencies with respect to digital rights issues actually acting more aggressively than they have in decades, and in long overdue ways. So, for example, we have the FTC is engaging in trying to rein in sort of the lack of competition in the big tech space, also doing a lot of work on privacy abuses that we see with sort of surveillance capitalism and trying to rein that in with respect to Google and Meta. And data brokers as well. So the FTC is this very activist FTC right now, and a good thing too, because it's well overdue. And then also, I'll just pick on two things or three things. Also, we have the FCC trying to reenact net neutrality rules, finally, to sort of make sure that our ISPs treat all the data that goes across their networks equally and fairly, which everybody in the public interest space needs in order to be able to reach out to people. And so the FCC has passed new net neutrality rules, and in the current climate, those are very, very much under threat. I think everything the FTC is doing is very much under threat. I'm quite sure that Google is going to point to Loper Bright when they get to the point of appealing the recent antitrust ruling against them and say that the FTC overstepped and misunderstood misunderstood the law and in its enforcement. All their lawyers are being paid a lot of money to think about this right now. And then the final thing that I think is really important for people to be thinking about is the area of algorithmic decision making, which we also have agencies finally, and Congress, but also agencies trying to step up and really rein in. Sorry, it's very noisy right away, and all of a sudden rein in the sort of misuse of algorithms to make really basic decisions about housing and employment and many other aspects of our lives, and asking agencies to, revisit what they're doing and change their practices. I think all of this is potentially under threat after Loper Bright, which is a real shame. I'm not saying the agencies always get it right. They've gotten it wrong many times, but it is kind of a sad irony from my perspective that just now we finally got some really important work happening in the digital rights space. All of that is under threat. It will take a while to percolate through, I think. We're a few years out from all of the legal challenges that we're going to see, but they seem pretty much inevitable.
Thanks. Mallory, any other thoughts?
Yeah, absolutely. Just, by way of background, as Andrew mentioned, I'm an attorney that represents nonprofits. So really our clients are at the forefront of this type of advocacy and policy change. And really what I do as legal compliance counsel is make sure that the organizations, nonprofits, either 501c3s or 501c4s, are doing so within the limits of the Internal Revenue Code and regulations. My time at Boulder Advocacy, which preceded my career here at Davis Wright Tremaine, was all about encouraging nonprofits to engage in bold advocacy. Even though as a compliance attorney, it's probably less exhilarating than the work that Corinne and Sanjay are doing. I always like to say compliance is strategy. And so if part of the end of the Chevron doctrine means that your nonprofit needs to pivot from perhaps administrative advocacy to more legislative advocacy. Josh talked a lot about pressing Congress. We can definitely talk a little bit more about what those rules are for your nonprofit to consider.
Yeah, thank you. And I think I will take you up on that invitation with our next question. So for each of you, could you talk a little bit about the ways that you see Chevron, the abandonment of Chevron influencing how you or the nonprofits you work with engage in advocacy, whether that's through changes in, how you initiate lawsuits or the kinds of regulations you challenge? What in this landscape is changing for you on the ground?
Should we just jump in, or?
Yeah, please jump in.
So I wasn't sure if that was someone in particular. Well, one of the things that I have been thinking about in terms of legislative advocacy is that one of the things that we argue for a lot when we want to see a new privacy law, for example, we've been advocating for sort of comprehensive federal privacy protections for a long, long time. And one of the challenges that we get, we would like to see that include what we call a private right of action. So we don't just leave it to agencies to enforce our new privacy laws. We actually let citizens do so themselves. There are pluses and minuses to that, but one of the things I think in our current landscape, I think it's really extra important to have that private right of action. So we don't just leave it to agencies to do everything, because a lot of what they do, unfortunately, I think we have to understand, is going to be subject to this automatic challenge, at least if there's enough interest on the other side. So I think there's a lot of reasons why you want a private right of action. You want to sort of make it, it helps give privacy laws more teeth. But I just also think I don't know if you call it a silver lining exactly, but one of the effects of it may be that, when we go into our legislative advocacy and talk to people in Congress about, how to craft bills that will actually be effective, we're going to have an additional reason why they need to include that private right of action if they actually want the law to have any teeth.
Yeah, I mean, actually, for environmental statutes, we often do have the benefit of a private right of action. I'll say for these things, it's not helping us very much because really when you think about things like climate change or even dealing with ozone, the government is really the only party that can comprehensively deal with those problems. At a high level, in terms of thinking what all this means or how it's changed our work, yeah, it really, I mean, the sum total of what the Supreme Court has been doing is really just to introduce chaos into the system. And I say that because, as Professor Travis explained, there's a reason why, the country has functioned this way for a long time. When you have questions like, how do you decide where one major source ends and another one begins? I mean, to answer that question, you not only need to know a lot about a whole variety of different sort of industrial facilities, right? Refineries might be different from power plants, might be different from chemical facilities. You also need the kind of elaborate public accountability system that the agencies actually have, right? I mean, not only do they answer for the most part to the president, so they're electorally accountable, but when EPA does something, it has to tell the public what it plans to do, take comment from every member of the affected public as well as from affected industry, and then respond to every meaningful comment in a way that makes sense, right? I mean, it has this institutional structure that is built to answer these questions well. Courts don't have any of that. And you have some courts in some cases that are, I think, very willing to implement their policy preferences. And that's, a problem because those policy preferences are not necessarily aligned with what the public might want or with sort of the public benefit. But in another way, you have judges who may very well be trying to be judges, but just don't have the tools to answer these questions well. So I think what we are finding, unfortunately, is just that even the sort of quotidian work of government has now gotten much harder and sort of proceeds in this jagged up and down, back and forth way, as opposed to what had been a pretty good system of producing reasonably good results, right? The government doesn't always get it right, but also a stable system where all of us could, look 3-4 years in the future and know what was going to happen. And now that system is very messy.
Just quickly from a compliance perspective, if your organization's advocacy strategies are going to be changing, your audience, right? Who are you now educating or talking to? If you're no longer advocating the agencies, are you pressing Congress or educating judges in amicus briefs or affirmative lawsuits? If you're a 501c3 public charity, influencing legislation, that is lobbying. And as a reminder, if you're a public charity, you can lobby. There are just some limits to those lobbying. Andrew said that I started my career at Boulder Advocacy. There's a ton of free resources online about the rules around lobbying. It's also not a coincidence that we're with Sierra Club, which is a 501c4. 501c4s, of course, don't have lobbying restrictions. So that's just the legal guidelines to keep in mind if you're going to be pivoting to educating and advocating for specific legislation, more specific bill drafting. Just be mindful of the fact that will count as lobbying. As a C3, you'll need to track that and report that to the IRS.
Yeah, thanks, Mallory. For our next question, it's related to the issue of courts not relying on agency expertise in the wake of Chevron being returned. So with that change where they don't necessarily have to defer, do you expect that outside experts might be even more important? And if so, like how could you be thinking about developing more outside expertise to argue for or against regulatory change in the future?
So for the environmental statutes, I think I would say that I am skeptical of the idea that throwing more outside experts at the courts is going to lead to better results. I mean, as I said, the courts they're just not equipped to answer these questions. I mean, that's kind of why Chevron has proven so important over the past 40 years, is that most judges have the law degree that I have. They don't have engineering degrees, right? And they definitely don't have the institutional capacity, and will not anytime soon, to consider thousands of public comments and sort of technical reports, decide which ones are good or bad. So inundating them with more expertise does not seem to me a likely path forward. Having said that, I think there are ways earlier in the administrative process when you're facing the agency where you can make the case more thoroughly that when this gets to court, the court should be looking to what the agency's done, right? The agency really does know what it's talking about. It has, in many cases, the agencies have decades of expertise implementing these things. Their decisions are based on really concrete experience in the regulatory field that makes sense, not just for, say, protecting clean air, but also for cost-effective solutions that are going to work for industry. That case can be made in front of the agency in ways that I think, well, I hope, will, at least in the places where we're not in the middle of the culture wars and sort of policy priorities are going to dominate, still prove effective when you get to court. And again, I think you're likely to have a judge who just wants to be a judge and is looking for like the cleanest path through a bunch of material that he or she really is not equipped to kind of parse for themselves.
So I don't disagree on that in the sense I don't think judges want to be inundated with a flood of competing experts. And I mean, we all know judges kind of hate experts and don't trust them. In my experience, there's a kind of a default there. That said, for EFF, kind of our foundational work 30 years ago was educating judges about tech, so that educating judges and government officials about new technologies so that they would make the right rulings, or at least whatever rulings they make wouldn't be based on just not understanding the technology at all. I think things have moved a lot. There's a lot more technological expertise than there was 30 years ago. And I think judges are more savvy than they were 30 years ago. That said, I do think judges are going to be interested in you know, they want to make the best ruling they can, or at least most of them do. They really do want to make the smart ruling and make an accurate one and have it based on, again, not every judge, but most of them, in my experience, that is what they want to do. And so it does create at least some opportunity, you know, if you can come in good faith, you know, I'm thinking here particular amicus work, and say, look, I'm just here to explain the technology to you so that you can make, you know, you can rule in the right way. Either supporting an agency if their ruling's getting challenged, or, you know, in some other capacity. So, and this is also true, by the way, for Congress. I think we've tried a lot in our legislative advocacy to come in and say, look, Congress, we're the people who are going to just explain the technology to you. Please don't just trust, you know, Mark Zuckerberg about how Meta works or whatever, or like bring in all the AI executives to come and tell you how the technology works. Like that is not a reliable source. And so I think Congress is going to need, I think Josh talked about this a little bit. I do think building up technological capacity is going to be absolutely essential on the part of Congress and on the part of agencies. And he's right, though, they don't have the money yet. Like they really need some funding to make this all possible. And in the meantime, I do think that, you know, independent nonprofits have a role to play if they have capacity to try to help them, you know, make better, clearer legislation that will actually, you know, withstand challenge. And then if the court does apply their independent legal judgment, which they still get to do, they will be better. They will also be better equipped to do that.
Yeah, I want to echo that. I do think that there's an opportunity for educating. You know, it's not before it reaches a judge, it has to reach their law clerks and the lawyers briefing the judges. And even though, you know, I'm a lawyer, and we're all late, you know, lawyers are generally lay people, particularly litigators, as a former litigator. So, you know, having educational materials that can educate folks who, you know, don't have backgrounds in science and engineering is going to be really crucial. You know, from the my lobbying compliance perspective, you know, I do want to highlight that there are opportunities for funding for nonpartisan analysis and research. You know, I think when nonprofits are thinking about lobbying and influencing legislative changes, there is some hesitation around lobbying because private foundations can't lobby. There might be some restrictions on their funding. And so, you know, an exception to the definitions of lobbying for private foundations is this exception called nonpartisan analysis and research. So there's some opportunity to get funding for white papers from large private foundations that might have been restricting their grants to non-lobbying activities. So that's just something to keep in mind for the educational component.
Yeah, thank you. And now I'll move to audience Q&A. So our first question is about state and local policymaking. So Chevron affected how federal courts engage in analyzing federal agency decisions. So are you looking at adjusting your advocacy strategies to engage more in state and local policies as a response, or are state and local policymakers playing any role in how you think about this post-Chevron world?
So I'm not sure that it's from our perspective, it's necessarily Chevron or Loper Bright that by itself that is affected much, but I can tell you that so EFF is located in the great state of California, and the decisions that are made by agencies in California affect many millions of people. So with that in mind, you know, we've been engaging a lot with state government, working in coalition with other folks, because it's just a little more possible to actually get things done in an effective way, and when the conditions are right. And so that's motivated, I think, our state work as much as anything. Is it's just, you know, it as everybody on this call knows, Congress feels pretty dysfunctional these days, and so it can be pretty frustrating, especially if you're trying to get something proactive done. Sometimes you can stop bad ideas, but it's hard to get something positive through. But there's a lot actually that you can do at the state level, and I think it's, you know, it's worth the candle, even if it can be kind of frustrating, because there's many issues that we all work on that really require federal action. It just doesn't seem like federal action is happening anytime soon. So maybe we'll start with the states and you know, see if that can be a model for federal action.
I mean, I think that's true across the environmental field as well. The one thing I'll add to that is that this is not so much a Loper Bright thing, but, you know, one flavor of the Supreme Court's jurisprudence has been that it doesn't want the federal government doing sort of big things, right? Like no like big steps. Everything has to be sort of small and incremental. But one, you know, possible answer to that, and again, I think some of this is also just hostility to regulation, so we'll see how far it goes. But when you have big states like California, New York, Massachusetts doing things like taking big steps, then by the time the federal government gets to it, right, there's less to do. Like they can establish a status quo in which by the time the federal government gets around to regulating, right, they are regulating against a baseline that's already moved quite a lot. And the steps they have to take are smaller. So there's a way in which those two pieces can work together that has the potential, at least, to answer some of the concerns that the court has raised. Again, assuming those concerns are sort of, if you take those concerns seriously on their face, as opposed to just a hostility to regulation. And I don't think we know which one of those things really is going to prevail.
Yeah, thank you. Our next question might be specifically for Mallory. So both the Sierra Club and EFF are larger nonprofits with a fair bit of legal support that can help them think through advocacy questions. So do you have any advice for smaller nonprofits that might not have that kind of support in-house, like advice on how to approach advocacy not post Chevron? Are there any resources that smaller nonprofits can turn to get help with navigating the landscape?
That's a great question, and just a great opportunity to plug. My former employer, Boulder Advocacy, they're a project of Alliance for Justice, and Boulder Advocacy has free resources on its website all about nonprofit advocacy. You know, the rules and regulations that apply to nonprofits, how they can engage in this type of advocacy, either administrative or legislative or judicial. So I really have to plug for Boulder Advocacy. They also have a technical assistance line. So, you know, I'm an attorney. I represent my, you know, clients and provide legal advice. But you can call Boulder Advocacy and get in touch with an attorney to receive technical assistance and answer some of your questions. So I would definitely start there if you are a small organization that can't afford, you know, in-house counsel or an attorney.
Yep, thank you. Our next question is about funding and fundraising for nonprofits. So does the panel have a sense of how funders are thinking about advocacy in the wake of Loper Bright? So typically, a lot of foundations might restrict lobbying, for example, through grant agreements. And I guess the question is asking if foundations have started thinking through changing those kinds of restrictions post Chevron being overturned. Maybe beginning with you, Mallory, since
Yeah. I mean, I don't, you know, I haven't yet seen, you know, our clients necessarily responding to Chevron specifically. You know, there are a lot of foundations that are dedicated to supporting nonprofits that engage in advocacy through, you know, general operating support grants. You know, if you receive a general operating support grant, then you can use that funding for lobbying and it won't impact the private foundation's restrictions on lobbying. You know, there are, you know, I mentioned the exception to lobbying, which is the nonpartisan analysis and research exception, you know, for receiving funding for receiving research and educational materials. There's also, you know, the project grant rule, which is where private foundations can provide project grants. and receive a budget that includes a lobbying amount and still find a way to fund that. So, I wouldn't shy away from telling your funders, your particularly private foundations, that you're interested in engaging in lobbying. As a C3, you're allowed to do it. I think really the trick will be about becoming literate on the rules around that, so that you can tell the grant coordinators that you understand the restrictions, you know how to do it lawfully, and that it's going to be a part of advancing your mission.
Thank you. And our next question might be best answered by Corinne. So government regulation of AI is a huge topic right now. Do you think that overturning Chevron deference might impact the AI sector? And how do you see that playing out?
I think it definitely will. There's a couple different things. One is that, as I referenced earlier, there's actually been an effort, good especially by the Biden administration, to have agencies review their algorithmic decision-making practices, and including how they engage with the private sector. And I have a concern that the rules that come out of that may be subject to challenge. And then more generally, AI is particularly, and I think this came, if I remember right, this came up in oral argument. AI, there's generative AI, there's algorithm decision-making, there's all this area in this space. It's moving really fast. Some harms are already well documented. There's future harms that we don't even know about yet. There's imagined harms that we don't know if they will ever come to fruition. All of these things, technology is going to change really quickly. I don't see how Congress makes a law that isn't outdated immediately. So it's exactly the kind of space where actually you would like, to the extent that Congress regulates, that they would delegate to an agency to actually act in this space as the technology develops. That's actually what you want in an area of technological change. And I really am very concerned that we're going to either get regulations that will be immediately outdated, or we'll get regulations that actually inhibit positive changes that we want in the world. And it'll be very unclear how they're ever going to be enforced, like enforced by whom. So it's a mess, to be honest with you. I don't have a good answer for you, except for it's likely to take a messy situation and make it messier.
Thank you for that, Corinne. And now I will wrap up. We always end on a depressing note, it seems. So we have one more question for each of our panelists. So if you had to give our audience, it's mostly like nonprofits interested in engaging in policy advocacy, just a bumper sticker, like one sentence takeaway about what the world post Chevron might look like for their work, what would it be? And maybe we can start with you, Corinne, and then move to Mallory, and Sanjay, we can give you the last word.
My bumper sticker is going to be the opposite of what I said just now. There's still a ton of opportunity to do good work. Take your knowledge, take your expertise, and use it as an opportunity to educate.
Honk if you love nonprofit advocacy. No, but really, to Corinne's point, there's a lot of work to be done, and your nonprofit can engage in advocacy. It can lobby. You can receive funding for lobbying. It is possible. And so, just get familiar with what those rules are. That's a long bumper sticker, but that's mine.
Yeah, like I'm an administrative lawyer, so bumper stickers are not really my, it'd be a long bumper sticker. I guess I would say, like, keep your eye on the future. This move, anti-regulatory move, is recent and still contested. And over the short term, I think, it's just brace for chaos. Like, it's going to be a mess. Over the long term, we have a set of institutions that has been very good at getting us like all kinds of like nice things that you can't have if you continue to break the institutions. And keeping an eye on that fight and sort of looking to reestablish the foundations of sort of 20th century prosperity is something that we should all be sort of thinking about as a project, as opposed to just assuming this is the way the world looks going forward.
Awesome. Thank you for the hopeful note. So thank you again to each of our panelists. And so now I'll just turn it back to Betsy for some closing remarks.
Thank you so much to you all for that robust conversation. I especially appreciated the emphasis on the need to expand advocacy to the legislative and judicial branch. We hope you feel a bit more prepared to approach advocacy in a post-Chevron world after today's conversation, and we also want to let you know that this webinar is just the beginning of the opportunities you have to work with the Aspen Institute to grow your policy impact. This October, we'll launch a new umbrella organization, the Aspen Policy Academy. The goal of this academy is to turn expertise into impact, including by supporting nonprofit organizations looking to grow their advocacy skills. As you heard through today's discussion, in light of the Loper Bright decision, we need subject matter experts more than ever to inform evidence-based policymaking. Courts and Congress are going to be able to decide more than ever before how policymaking happens, and whether we prefer this outcome or not, they will increasingly rely on outside experts, not agency staff, to inform their decisions. Through policy training boot camps and workshops on topics like how to write a public comment and how to testify before Congress, the Academy will help ensure that researchers and academics can more effectively engage in and influence policy. We hope you feel inspired to use your own subject matter expertise to influence policy work, and join us for one of our future programs to learn more about how to have policy impact. Subscribe to our listserv and stay tuned for more details as we launch in late October. Before we close, we want to say thank you again to our lecturer, Josh, and our incredible panelists, Corinne, Mallory, and Sanjay. We really appreciate you sharing our expertise with us today. I'd also like to thank our Hub staff who helped make this event happen: Andrew Lewis, Maya Sisla, Connie Moore, Kate Green, and Gloria Molina Estelano. We are really excited for what's ahead for the Aspen Policy Academy and hope to see you at our upcoming launch events and to participate in future programs. Thank you again for joining us today.